The current Commissions of Inquiry Act, as many orators have said, honorable members have said, dates back to 1944. I hardly can understand how Honorable Jubal says we should keep that act and amend it. Its structure, its functioning are completely outdated and no longer provide an adequate response to the variable complexity of the matters that may in a modern society require the scrutiny of a statutory inquiry. First of all, let us, Madam Speaker, look at what the commissions of inquiries recently under the previous regime have come out with. When the former Justice of the Supreme Court, Mr. Lam Shanni, and his two members made a serious and sustained effort to reach the truth in connection with the social scourge of drug trafficking, which has increased vastly in recent years. His alarming findings and shocking conclusions, what happened to them? They disappeared into a void. The former government ignored most of its recommendations, and it cost the taxpayer 12 million rupees. Most of its recommendations were ignored. Similarly, when a public inquiry was set up to examine the conduct of the former President of the Republic, it subsequently, the leader of the opposition was talking about trying to politicize things. It was subsequently appeared to have originated from an anonymous letter concocted in the Prime Minister's office by a special advisor of the Prime Minister, the then Prime Minister, who then promised to lay the letter before this House for scrutiny. It was predictably unfulfilled. That promise was never kept. No letter was ever deposed here in the Assembly. And it cost the taxpayer 10.5 million rupees. When the Commission of Inquiry into Horse Racing was set up in 2014, its preliminary report mysteriously disappeared after the general election of December 2014. And the interim report was, I think, tabled only in 2017, rather than government. But, Madam Speaker, not by the government, it was tabled by the then leader of the opposition, the honourable member's father, Zabeluk Jubal. He is the one who tabled them. It was never tabled in front of the House. The Commission's findings and conclusions were submitted by the then President of the Republic, Mr. Kailash Prayag, to the then Prime Minister in March of 2015. I remember, purposely rang the then President to ask him to make sure that the Prime Minister gets the report, because it was an important report. It was about what was happening in the Mauritius Turf Club. The President told me that he has asked his rider to go and leave the report at the PMO. Question was put to the Prime Minister in Parliament, and without flinching an eye, he said he had never received the report. Disappeared completely. When international arbitrators awarded billions of rupees in damages against the reckless and irresponsible political scorched policy of the previous government in the Betamax case, dismissing the previous government case, the arbitration, for that politically motivated abuse and as lacking any shred of evidence. When the Privy Council dismissed with disdain the government's legal challenge to the award, and the independent DPP rejected the trumped-up police investigation for the bogus smoke screen it always was. What did the previous government do? Precisely what the leader of the opposition is complaining now, who was a member of the government, if I remember. And now he seems to be worried about exactly that. But this is what happened under the previous government. Let me give a you a concrete example of how the previous government weaponized commissions of inquiries to settle political scores. The House may recall, we spoke about him this morning, how the now notorious Sattar Haji Abdullah, with the connivance of the former Prime Minister, together, they tried to convince Mr. Dawood Rawat to get rid of the BIA group of companies for the symbolic sum of 1 rupee, with the promise that if he did this, the government would not harm him or his daughters. That was what was done. And Mr. Rawat, to his credit, categorically rejected this poisonous offer. And yet, I think, I can't remember, I think Honorable Utim mentioned it, the very same Sattar Haji Abdullah was appointed as an assessor of the Commission of Inquiry on the disposal of shares of the BI Company Limited. And also with the related, I think it was called Britam Holdings Limited in Kenya. If this was not a direct conflict of interest, what was it? What was the guarantee then under the previous Commission of Inquiry? What was happening then? Exactly what we want to prevent, actually. It is worth pointing out that one of the recommendations of the Commission of Inquiry, chaired by former Judge Duma, Bhushan Duma, was that criminal actions should be initiated against former Minister Roshi Badin for his malevolent acts in the sale of the shares of Britam Holdings Limited of Kenya. This is what Duma said. And what did Mr. Badin do? He swore an affidavit where he pointed out that one of the assessors, Mr. Sattar Haji Abdullah, is a bosom friend of the former Prime Minister, and therefore he's judge and party in this case. And that was the end of the matter. Finished, forget it. In the drawer. And these three commissions, Madam Speaker, cost the taxpayer a total of 32.7 million rupees with no result to show. Nobody in the House had any idea what the Commission of Inquiry said or did. These Commission of Inquiries were set up for the wrong reasons, and their findings, their conclusions, their recommendations were completely ignored, left to sleep in the yellowing pages of newspapers and the dusty drawers of the administrative inertia. We have seen just such pattern for the last wasted decade. Inquiries have come and gone. They might as well have never happened. Let us come to the inquiry on Betamax, which we are being told was stopped on purpose by this same Mr. Badin. This is what he's been campaigning about. Let us look at the facts. The case went for arbitration in Singapore, presided by a UK former judge with high reputation. High reputation. The arbitrator stated, after having examined everything, that the allegations of fraud was completely unsubstantiated. There was no proof of any impropriety. Arbitration, if you look at the law, that should have been the end of the matter. But no. The government then decided that the findings of the arbitration should be ruled out by the Supreme Court as it was against public policy. In spite of the fact, as I said, the International Arbitration Act says that an award should be final and the courts should not readily intervene. However, the Supreme Court intervened and cancelled the arbitration award. Betamax went to the Judicial Committee of the Privy Council to appeal. Look what the Privy Council said. The Privy Council said that the Supreme Court of Mauritius was not entitled to review the arbitrator's decision. The contract was not illegal. There was no impropriety. And it added that the Supreme Court cannot, under the guise of public policy, reopen issues that were settled. That's what the Privy Council said. Une claque magistrale à notre Cour suprême. That's what happened. And that should have been the end of the matter. The then government wanted to initiate after that, after the Privy Council had pronounced itself, and not a commission of inquiry as if as a fig leaf, I suppose, to disguise the slap they had just received after a final judgment of the Privy Council. I think Honourable Minister Utim rightly said, it is a contempt of court, that action. Du jamais vu. And they started a commission of inquiry. You know how many years after? It was 15 years, practically, after a commission of inquiry started. It was a sustained, dishonest campaign, a conspiracy at the highest level to manufacture evidence, especially against me, but also against Minister Beju. This was the purpose. The Honorable Juval should have looked at what his own father said at the Commission of Inquiry. I suppose you didn't look. It was, you were there, but then you didn't hear anything. You were there for nothing. Because you should see what he has said. Madam Speaker set up a public inquiry to cover the embarrassment after la claque qu'ils ont reçue. There was never the slightest basis for such an inquiry after the Privy Council had pronounced itself. It was, in fact, meant to find ways and means to taint our reputation with invidious charges. Nothing more. And it awarded, in awarding over $100 million US against the state, which we had to pay. The taxpayer had paid. The distinguished independent international arbitrator scathingly dismissed the previous government's supposed justification as lacking even the semblance of plausibility. After thoroughly reviewing all the evidence the government had put forward, they found no basis to suggest that any impropriety whatsoever had occurred. As I said, these findings of the arbitrator were supported by no less a court than the Judicial Committee of the Privy Council, which decided that the previous government's case to be spurious and founded on elementary misconceptions of the law. In taking its decisions against Betamax, we all know, of course, Madam Speaker, that the previous government was assisted by legal geniuses, some of whom to this day no doubt continue to avert their legal services, their legal wisdom, at considerable cost to their unsuspecting clients. They're still taking money out of people. But no cost will be ever as great as the cost to Mauritius of their reckless, politically motivated and foolish advice. Mr. Banner, all he has been talking about, he was instrumental in both the BAI Commission of Inquiry and also the Betamax one. And he is continuing to make unsubstantiated allegations during the campaign. As I say, you should have heard, if you were there, I don't know why you didn't hear it, what the former Deputy Prime Minister, Navin Ramgoolam, said. He said he did not agree with that decision of Cabinet. He told Cabinet that this is a wrong decision. He was there at the beginning. He knows there was no impropriety and that it was going to cost us money. He even called in the then Solicitor General, Mr. Duran Debi, and asked him his opinion. And Mr. Duran Debi said to him that he was completely opposed to the cancelling of that contract and that the government will have to pay heavy damages if they do that. But, and they instituted the Commission of Inquiry. 15 years later, as Honorable Utim just said, it was a contempt of court. And it would have been challenged had there been this interference, as we think there would have been. They would have been challenged in front of the Privy Council again. Mr. Banner should be exposed, Madam Speaker, for what he is, like a vulture with a mixture of venom and ignorance. Ignorance. It's reprehensible beyond contempt, what he's been doing. This is what SSR used to call a flash in the pan. Yes. He has been reduced to a political farce, political clown, I should say, ready to do anything to cling to even concrete for his survival. I know, Madam Speaker, you might say he's not in the House, but it is precisely because of this that I'm dragging him in here, to expose him. What a loudmouth demagogue he has been, dangerous demagogue. This is the background. This is the background of the Betamax case. The Mauritius public is now asked to support many more millions of rupees to be expended on a pointless public inquiry purely for political ends and because the previous government could not accept the responsibility of its own flagrant abuses. It has been proved. 2 judicial tribunals, including the highest in the Commonwealth, have denounced it. We know that the previous government didn't care about money. We heard this morning. They have brought this economy of our country to its knees. The House, Madam Speaker, has a duty to put an end to this long legacy of waste, self-enrichment, and abuse, which if we were left to continue, would cost again the hard-pressed taxpayer even more millions. This is what would have been the result. We all too plainly know the cynical exploitation and abuse of the state's resources, to which the government unhesitatingly resorted to whenever its political and personal interests required. When this Monsieur Moustache leaks exposed their shame in all its nakedness for all the world to see, placing on show the tawdry, corrupt, and abusive nature of this criminal gang, which had seized and maintained control of the country by fraud and by lies. What was their first response? Yes, Madam Speaker. They announced a public inquiry into the leaks. Never. It never happened. There was never even a public inquiry was never started. It was just a show because the elections were there. People were revolting. So they said, well, inquiry. No inquiry was ever done. But the Mauritian people put this, what I could call a dying serpent, out of its misery, whose coils had wrapped themselves around the country, and at least to save the country public purse. And what has been the cost of all this? Tens of millions of rupees, as I said earlier, by the government on sterile exercises of political self-justification, not counting the time. We don't put the time of what the civil servants had put in, which properly accounted for even more tens of millions of rupees. Yet, not a single recommendation has been adopted. Not a line of any of the reporters debated in this chamber. Nobody knows what is in the Commission of Inquiry. No official government response. That shows, Madam Speaker, that in the hands of the previous government, there were no more than colorable devices again. They were never intended for the purposes for which public inquiries are supposed to exist, to cast light on social ills or public mischiefs, to establish the truth of tragic events, to apportion responsibility, and to lead to the diagnosis and remedy the causes. First, then, we will put an end to that shameful chapter and abusive inquiries of the previous government. Secondly, we will ensure that the conclusions and recommendations of the inquiry will not simply be ignored by future governments. They will have to be debated in this chamber. Never happened before. The government will have to publish a formal response, recommendation by recommendation to a report. Now, I heard Honorable Juval ask, it's a misconception, complete misconception of the Constitution, of our system of government. We have a cabinet system of government here, not a presidential system. The president has to act on the advice of cabinet. And as I think Minister Subon just said, who is the head of the cabinet? Who is the head of the cabinet? The Prime Minister, perhaps you don't know, meets the President every Thursday morning. It's in the Constitution. I have to keep the President informed. I meet him every Thursday morning. He's kept informed. When the bill, we propose a bill, he sees the bill. If he has anything to say, he says it. This is how the cabinet system of government works. And the determination of this government is to widen, to deepen, and strengthen our democracy. And in fact, I don't know where he's getting his quotations. In Canada, in the UK, this is the system. The UK had the same system, go and look, same system that we're putting here. The Public Enquiries Bill before the House provides for a legally robust framework in the conduct of public inquiries into matters of significant public importance. And it provides for the setting up of a board of inquiry with much wider powers than existed before. Events having caused public concern or capable of causing public concern. That also has to be taken into account, as well as where there is a public concern that a particular event may have happened. Sometimes it is like this. It will now fall under the scope of that new board of inquiry. The bill creates for more specific and detailed terms of reference. Additionally, and perhaps the Honourable Juval doesn't know, how do we decide the terms of reference? It is in Cabinet that we decide the terms of reference, but that's how it is. The Prime Minister is in the Cabinet, if you don't know. He heads the Cabinet. This is how it is done. You're thinking of the kitchen cabinet, I think. That's what you're referring to. It's not the kitchen cabinet here. It's a real cabinet. It is. And the Prime Minister will now be possible to consult the chairperson or the proposed chairperson of the board before setting up the terms of reference, instead of just putting terms of reference, and you see the chairperson say, I don't like this, I don't like it. At least we'll have consultations, and he will be able to respond to these terms of reference. Furthermore, there shall be a statutory duty to inform the National Assembly. This is not the case with the actual Commission of Inquiry Act. We will have to inform. When a board of inquiry has been or will be set up, the terms of reference will be seen in the National Assembly. You will see who shall be appointed as chairperson, and also whether the Prime Minister has appointed or proposes to appoint any other member. Additionally, and most importantly, in order to avoid the delays we have seen in the past with former commissions of inquiry, there will now be a statutory duty to state the date by which the inquiry report must be submitted to the National Assembly. It cannot go on for years and years. That commission of inquiry on Betamax was 15 years ago. Now they were calling us to say, even your father said to the judge, Madam, it's 15 years ago. How do you expect me to remember everything? It's impossible. This will not be the case now. There will be a statutory duty to state the date by which the inquiry report will have to be submitted. Furthermore, in a spirit of transparency, while the Commissions of Inquiry Act provides an option as to whether the inquiry shall or shall not held in public, this one makes statutory provision for the Board of Inquiry to be held in public, unless, for some reason, security reasons perhaps, the board decides otherwise. The new bill also makes provision for members of the public to be able to obtain or view a record of the evidence given and the documents produced or provided during the proceedings of the board inquiry. Your father complained. I also wanted. I wanted to know what other people have said so I can rebut the arguments. No, you can't have it. At the end, they said you can go in and look at it, all sorts of boxes of documents, and you have to do it within a few days. Not possible. What's the point of hiding it? We have seen how in the past, how many people have had their reputation damaged by their name being mentioned in the reports of the Commission of Inquiry they have to go to judicial review after that. Well, they could have done it there and then. We have seen how there have been no explanation sought from these persons, who then had to go to the Supreme Court through judicial review. I had to do it myself. And I won. On top of that, I won. Out of the 5 complaints I made, I won 4. On the 5th one, they said it was a balance. Maybe yes, maybe no. In a spirit of fairness, the Public Enquiries Bill makes provision for any person who, in his opinion or his or her opinion, the reputation is likely to be affected by public inquiry. They can be heard, they can be given evidence, they can produce documents, and they can see what has been said against them. According to the bill, the Prime Minister shall not later than 30 days after receiving the inquiry report, he will have to lay the copy in the National Assembly, on the table of the National Assembly. In other words, it will not disappear in a drawer. You will have a chance to look at it. Furthermore, the Board of Inquiry shall not later than 30 days after the submission of the report to the Prime Minister, publish it in the Government Gazette, so everybody can look at it. And there will be a new statutory duty on the government to respond to the report. not just laying it on the table, you can debate it. This doesn't mean that the government will be obliged to accept each and every one of the conclusions, but it will mean that the public will be able to see what the arguments were, what the government proposes to do about the whatever mischief and identified by the inquiry. These measures will also ensure that the work of the board will be conducted in a transparent manner and made accessible to the public at large. Honorable Tim rightly pointed out about this drug baron or drug peddler who had said he knows who in the government has been financing, taking money from the drug barons for the elections. These have been thrown under the carpet. To conclude, Madam Speaker, let me reaffirm that the government today is honoring its commitment to provide clear parameters for the conduct of public inquiries, including, as I said, a strict time frame for such inquiries. We are repealing the Commissions of Inquiry Act and replacing it by modern, transparent, and comprehensive legislation. The government is taking steps to ensure that the purpose of the public inquiry is purposes are generally fulfilled, not abused, like it had been done in the past, and the reports are not simply ignored. In fact, the reports were never known. Here you'll get a chance to see how much it has cost, and you can see the fairness, the independence, and accountability of the whole process of this public inquiry, with the rights of everyone who might be affected by the findings of an inquiry report. They have a right to come and depose. I have repeatedly said, Madam Speaker, that one of the imperative missions of this government is to restore integrity, pride, and independence to the constitutional, democratic, and civic institutions in which the freedom and strength of any nation principally resides. The bill contributes to that cause. Thank you, Madam Speaker.